We're live on PM Express tonight, and is an assessment of the work of the special prosecutor. 1 year after that office was created, there have been, out of the 15 cases that has been filed, one case has been filed in 15 months. So is he winning the fight against corruption? This is what we'll be assessing on the show tonight. And in fact, today we've had an assessment from civil society groups who've been looking at this quite strictly. We know it's been 15 months already since the office was created. Ahmed was sworn in as Ghana's first special prosecutor. There was a lot of excitement when, in fact, he was sworn in. Many Ghanaians are beginning to question what he has achieved over the last 15 months. Now, we've been looking into this because we needed to interrogate what really has he done. Out of the show that out of the 25 cases before the OSP, only one has been filed so far. Now, it includes Information Minister Kojo Nkrumah is being investigated, we understand, for alleged abuse of office involving Ash Plant Pool Company that the OSP is looking into. We also know that 9 other political appointees are all subject of investigations into various issues that the OSP is interested in. Now, they include MPP MP for a Krofo constituency. Now, in the Ashanti region, Kwabena Apia Pinkra, who's also being looked into, the Deputy Finance Minister, Charles Edubuahin, who is a respondent in the case in which he is alleged to have used his public office for private benefit involving the processing of government payroll. It's also subject of some probe by the special prosecutor. Now, the MPP chairman, Freddie Blay, remember his 275 buses bought for the constituencies in the lead up to the party's internal leadership contest. It's also a subject of some probe because the OSP has been petitioned to look into this. Also, there are pending cases, alleged diversion of public funds to finance NDC party research that we brought to you here on multimedia channel. There's also something that the OSP is interested in. The special prosecutor, we know, is yet, though, to assign an investigator, we are learning also, to the Edubuahin case, while there is already an investigator looking into the allegations against the information minister. Also, there are challenges, by the way, that has come to light tonight. The Anti-Corruption Office is facing a human resource challenge. We know that. It has only a lawyer and 3 investigators, woefully inadequate, civil society tell us. Now, the work of the CID and OSP on the Metro Mass, for example, and the Charles Bisu investigations is overlapping. And civil society believe that is one of the key areas that needs sorting out. And we'll be looking into that also. CDD did a press conference today. Well, not CDD alone, together with other like-minded civil society groups. There are also calls for all board members to declare their assets, something that we'll look into tonight on the show. So there's a fundamental question that needs to be answered tonight, which is the OSP winning the fight against corruption? We'll be doing that with the civil society organizations that came together today to do an assessment, of this OSP's work in the last 15 months. Stay with us here on PMS, and we'll get to the bottom of this when we return from the break. You're live on PM Express tonight. My guest in the studio is Dr. Kojo Asante, Director, Advocacy and Policy Engagement at the CDD. But today he was the mouthpiece for Corruption Watch, the CSO coalition on the OSP, and others as well. The roundtable discussion that assessed the work of the Office of the Special Prosecutor over the last 15 months. And this is the first time this has happened. and Kojo is joining us in the studio. Kojo, I'm guessing this is the first of many such assessments.
Sure. I think we have civil society in particular, those working on anti-corruption has invested in the OSP. We were very much part of the process of developing the legislation, and we believe that it was a critical tool for turning the tide against corruption, and that's why I think we all supported it, and that's why we have been keen to follow its evolution, because we know that if we don't get it right from the beginning, then it might succumb to some of the other challenges
that we've seen
with other law enforcement,
etc., etc.
So
okay,
yeah.
So that's why you're keeping an eye on this.
That's right.
Okay, we'll tell you what they found shortly. Some fascinating details in there. I'm sure you can see behind me, and that is Justice Srimsai. He's law lecturer at GIMPA. Hello, Justice. Thank you for your time here on PM Express. We'll bring Justice Srimsai into the conversation shortly. He's joining us, of course, to assess, of course, how the OSP Act itself has been interpreted the last 15 months is an issue that the CSOs have highlighted. But let me start from the bottom.
Yes.
And you say at the conclusion that if we have lost time at the beginning, we should not lose more time now. And you make a fascinating point about what for you is the conclusion of this. After a little over a year since the office was established, we have seen progress, but it has not been fast enough to meet the expectations, some of which were admittedly unrealistic. Fair to say that after 15 months, expectations haven't been met. Is that
yes,
the assessment?
Yes, and I think, but at the same time also, we admit that some of those expectations were unrealistic. But I think if you look at the chronology that we try to describe in the assessment, we lost a lot of time between appointing the OSP, setting up the board, and all of the other infrastructure that needed to be put in place. And I make a very, for me, an important point. It might be disputed by government, that we really did not appreciate the scale of the task that was needed to get the office in place. The fact that the OSP stayed in this 3-bedroom space for that long suggests to me that we did not envisage right from the beginning that first of all, you will need a bigger office. Even if you were going to recruit people to work in a place, you needed a bigger space for that to happen. And we took too long in trying to get to that problem. It was only after the OSP had really gotten frustrated with having to do with that initial allocation of a property that we began to look seriously at a much bigger place. And so I think that period of time we lost has not helped, because it has impacted on a lot of deliverables. Recruiting lawyers, getting legislation passed, getting infrastructure and logistics in place, so that as this is all going on, people are sending cases to the OSP. Everybody is going to the OSP that, investigate my case. So I think for me, that was a missed opportunity. But as I said, that is lessons learned. Now we have most of the things in place. We just have to move quicker.
And you compiled some of the cases in your report, and we ourselves have also been in touch with the office and gotten some documents. And from what we see, the Mahama Yaga case appears to be the only case that is in court.
Yeah, I mean, as far as I understand, and as you know, the special prosecutor has stated time and time again that unless he is meeting the expectations of the statute, which is that every half year he will publish cases that are investigated or are in the course of proceedings in court and so on. He's not going to talk about cases that he's investigating.
Cases,
and he makes the point that he needs to also protect the rights of those accused, because until he decides that there is a case to be made against them, You shouldn't be going out there and sort of ruin their reputation. But of course, what has happened is that in some cases, the complainants themselves do indicate that they have brought a case against an individual, and that it becomes a matter of public record. So in those instances, you can't really fault anybody from knowing that somebody is being investigated, because if you bring a complaint, like in the Analysis case, where he announced that he has sent it to the special prosecutor acknowledges publicly that he has received that case. That becomes a matter of public record, and nobody can say that it's something that has to be kept secret. But so we even based on those cases and some of the issues that have happened around them, like parallel investigations and so on, we have raised some concerns with that, and we think it's an area that the board, should be able to act on as quickly as possible.
For many Ghanaians, this is a challenge. Martin Amedu, as a private citizen, was very successful in prosecuting cases with his own resources. I mean, in the history of this country, I guess, and in my generation, I have not seen anybody like him before. When he took matters on, went to court, won the case, when even the state agency constitutionally mandated to do so had failed to get monies for us. I'm talking about the agency department. He did and won the cases. And so people wanted to reconciling that Martin Amedu, the private man, and the Martin Amedu now, who now has the powers of the state at his disposal, and doing far less with the powers of the state at his disposal than what he did when he was in private practice or as a private citizen. And they can reconcile the two and they say, for example, he didn't have any resources as a private citizen, but you did that. You didn't have resources now, and you're not doing anything. Well, do you understand that expectation?
Yes, but I think also it's quite simplistic, because I think that if you take the case, the Woyobe case, which basically was an application in court, you wouldn't say it was an investigation. I mean, to some extent, you can say at least he was more intimate with the case because he was the Attorney General that was pursuing it until he decided to leave, for the reasons that he did. So he had obviously gotten a lot of information before he left. It's something that he was working on. And then, but if you take all these cases, whether it's the Anas case and so on, so forth, if it to go through the evidence, you will need people to sit down and do that. All right. Now, in the current space that he is, where he and plus Madam Cynthia, who are the lawyers, and I am hearing that there's one more lawyer that has been employed. They are basically the only people that can take a case to court. The investigators, who have maybe 2 or more, 3, 4 cases that they are also investigating, have to also look at that video for God knows how long. So if he wants more people, he won't find a space for them in that space. He has to get a bigger place. So you can recruit people and you can't even find a space for them.
Are we saying primarily his problem is a space problem?
No, and I think we were quite thorough in the assessment. That
there are others.
There are others.
We'll examine them, but let's look at the building. How much of that is a constraint?
For me, it's a huge constraint, because it has to do with the numbers and the ability to be able to take on a lot more and do things faster. Because, as I said, it is a 3-bedroom house. The detectives are using the boys' quarters, and you have a conference room downstairs. And the rest is basically 2 rooms or 3 rooms that are shared between the special prosecutor, the deputy, private secretary, and administrative secretary. So even if you recruit lawyers right now, they won't have a place to work. So that is important. And the fact, as I said, that's why it is unfortunate that took so long for people to recognize that he needed a bigger space in order for him to carry out his mandate. That has stalled a lot of things. So there are a number of cases. He's acknowledged receipt, but I doubt how much the detectives could do with any of those cases at the speed that people want it to happen. It's not going to happen.
Let me bring in Justice Stram. Sorry, Justice. So, what's your own verdict, having observed the office of the Special Prosecutor or the work of the special prosecutor for the last 15 months? Happy with what you've seen?
I would say that the special prosecutor's office, as is currently set up, cannot deliver the object that we all had in mind when the process started in 2017. Now, Evans, let's go back. At the core of the special prosecutor's office, the core of the establishment, is the issue of political will. You remember that one of the reasons, or the only reason why the issue of special prosecutor came to the fore, was because over the years we have found out that attorneys general of the past have not been able or willing to prosecute their colleagues in government. So in order to overcome this challenge, the office of the special prosecutor idea was mooted in the NPP manifesto, particularly page 39. In that statement, the key issue was independence. And the independence was used because we wanted someone who can focus on prosecuting persons who are in government. Of course, because we'd never had any special challenge with an attorney general prosecuting persons who were in government that were not his government. So the mischief to be cured with the special prosecutor was to get someone who was independent of the government in power, who can prosecute persons who are in government. If you follow through that object, you will notice that then the focus of the special prosecutor will be very narrow, thereby giving him control, capacity to overcome the challenge we envisage. Now, fast forward to the act. What we have now is an office which merely has a broad scope, almost constituting a department under the Attorney General's office. So the special prosecutor focuses on all cases of corruption, political corruption, those that are captured under the Act 29, and then the Procurement Act. Evans, that is huge. That is so huge. So obviously, the intention or the idea that we had in mind did not materialize. So what we are seeing now, and from what my learned senior Kodo said in the studio, it is true, as he said, that we are not delivering. The special prosecutor's office is not meeting the expectation, and I doubt if it would ever meet that expectation.
Why? Is it simply because you think his mandate as prescribed in the law is too broad, or is because of lack of political will to I guess resource him to deliver? Where do you put it?
One, it is the lack of political will which led to the overbroadening of the scope.
You're almost suggesting that the scope was so broad and was broad deliberately because we knew if we give him that scope, he can't deliver anyway. As to whether it was broadened, as to whether it was done not to make him ineffective deliberately is what I can't tell. But the result, as it is now, is that it will not be effective because the scope is overly broad. Evans, and the evidence shows, look, if the political will is there, then first of all, having gone through the enactment of the act and having cut the scope by the government in power, then you expect that the resources that will match the scope of the special prosecutor's jurisdiction should be provided. But what did we start with? A 3-bedroom house, no employment, no attorneys, investigators. So if you put all these together, Evans, you will realize that the problem we were trying to solve, which is to dissolve the lack of political will to pursue corruption, is persistent.
And the only difference here is that it is put in a container, or it is put in a position which makes it look like it is going to do something kind of a scarecrow. So you know how scarecrows operate. So it is in the farm, and the crows come. It can't do anything, but the crows will fear. But the moment the crows decide that, look, let's challenge and come close, they realize that it can't do much.
It can't do much.
Hold
on there. I want to bring in Kojo. Kojo, there's something you said that seemed to emphasize it. In fact, not something you said, something that Martin Amidu himself said that you quoted. And this is on the page 2 or so of your page. He says, he put an article, and then he compared the situation with the Whitaker scenario. And he said, and the scenario outlined by the then, President Trump's acting Attorney General, who was Matthew Whitaker, where he had envisaged a scenario where the Special Prosecutor, Robert Mueller, who was conducting a probe into Russia meddling in the U.S. elections, could be underfunded to an extent that the probe will come to a halt. Is that what is happening to the OSP now? Because if you listen to Justice Ramsay and the others who I've heard today, in fact, anti-corruption campaignners, who silently tell you that they have the same suspicions, that, for example, again in your report, the Finance Ministry, and I make a note here, this sounds simple enough. It says the Finance Ministry, in terms of foreign grants, for it to operate. If we don't have the money, foreigners can help you. And you've noted there are there's a lot of interest there. However, you noted the Finance Ministry will still need to issue a direction note on how it will process such assistance. And I'm wondering, 15 months on, a direction note should not take 15 months on for that to happen. And that sounds simple enough.
I take, Justice's commentary on the design of the law. I mean, I was intimately involved with that, and I can tell you that there were debates as to how to narrow the scope, broaden it, and so on, all with good pros and cons. And at the end, I think a position was taken. Even I think in the LI, Mr. Amidu, for example, was still very strong on whether or not the office should have a preventive role as well, because in the debate, people didn't think that the OSP needed to be doing any education, that Shraj was there, other people were there, and so on. So I mean, these debates will continue. So, I mean, I don't think it's a matter of scope, because as I have tried to lay out, for me, the issue that you raised, for example, that it is fair that at some point between the time that he was appointed in February and somewhere close to, I think, after the board was also constituted in July, he began to feel the frustration because he felt that things were not moving fast enough. Now, the question is, and that's where I have tried to, my take on it is that I don't think people really appreciated the scale of the job that they had. Maybe in the mind of the people who thought about the special prosecutor, it was getting them an office so that they can start working. But you talk to law enforcement people who know the seriousness of this stuff. The special prosecutor, for example, has police powers. So even if he arrests somebody, he needs an interrogation room to work. And if you don't have somebody who has that expertise and is advising on that, I mean, we at the beginning said the office should, the AG and the government should have a task force where you bring people with expertise. There were so many people willing to help lead the special prosecutor. So why it took long for that process to happen, for me, was where the disappointment that it took Mr. Amidu to come and start talking about that before we started looking for buildings. And yes, government responded, and even has responded with the 180 million, which he has.
Which he has now?
No. I mean, by the budget, they don't pay it into your account. You have to disburse. You have to request for disbursement. So, but the point is, even if he wants to access that money, he has to, if you're going to do recruitment, then you have to request. But how are you going to do recruitment if you haven't gotten the new big building to send your new recruits in there? So these are more practical things than scope.
But I've seen that you're recommending that the recruitment should be done in anticipation.
Sure, but what I'm saying is that we have to move quicker. So rather than thinking in sequencing, we should think parallel.
Okay.
So you know that, okay, the office should be ready in the next month. Because the office is going to be ready in the next month, we can start the recruitment process, because that will take time. So I'm trying to see a process where we all are trying to act quicker than we had done in the last year or 15 months. That's my sense. But most of the things I see is practical, and I just see that in most of these cases, people who are probably advising or are supposed to provide these logistics don't really appreciate what is needed to get this thing moving.
But then you see his point about political will, right? Because,
people can describe it as political will.
Why wouldn't you appreciate when I think the country agrees? In fact, the elections of 2016 was won on the subject of corruption.
Sure.
And so for a government that won the elections, you would think that this is something that will come to them naturally.
That's a fair commentary, and I think it's for government to respond to that. But what I'm saying is that sometimes for what I've observed, people just, the way they thought about this office is not how Mr. Amidu saw it. And when we had engagement with him, that is when we realized that there's so much water that has gone under the bridge that we could have, tried to address.
Justice, isn't this a pure case of teething problems? We've never had this arrangement before. We just created it in 2018, was it? And so you expect that these challenges will happen. It will take time for all these problems to be sorted. It happens with any institution that is created for the first time, isn't it?
Evans, yeah, it does happen. But the issue here is this is not the first time we are prosecuting corruption in this country. The experience of prosecuting corruption, the challenges that institutions of criminal justice face are not new. So if you are bringing in something new, we expect that you will have in mind some of these challenges and probably have worked against them. For example, take the issue of accommodation. If you have someone whose job is to prosecute corruption, all forms of political corruption, including procurement, crimes. A 3-bedroom, you don't need a scientist to tell you that a 3-bedroom is not adequate. So this is something that we could have solved. Kojo mentioned other issues about personnel. You don't need to go through it to know that you need this number of persons to be working. You don't need to go through it to know that, look, we need this logistics. We don't need to go through all this to know that we need this particular set of expertise, this capacity. These are things that we can actually do before we even start anything. My point is that even as we work on this, let us admit and be upfront with the point that the scope is overly broad. This is just the beginning. Very soon, petitions will fly in on procurement alone. Now, how many criminal sections? Over 20 sections in the criminal and other offenses, act are supposed to be within the jurisdiction of the special prosecutor. How does it solve it? If you have a working knowledge of how even the Attorney General's Department work, you will realize that even under the office of the Director of Public Prosecution, there are so many desks taking care of, things that are not, there are so many desks there. Now, the question I am asking is, if we are not ready or willing to admit that the scope is overly broad, the challenge we are going to face going forward is that we will live in that denial and still be expecting that something new, something drastic will happen. And it will happen. And the special prosecutor will be frustrated, and everyone working with him will be frustrated.
But if you read the law, Justice, the fact that the case is filed with the OSP doesn't mean that it must necessarily resources must be dedicated to look into it. The OSP has the power under the law to choose and pick which case gets priority,
Yeah,
in which case
yeah,
it's
so
investigated.
that choice,
So
decision
that isn't that the cure to the broadness, because the OSP will have to make a decision out of 30 or 50 or whatever number of petitions that come before him. We have to sift through it using its own, criteria and decide what to focus on.
Yeah, so that is where the question is: what guides his discretion? Is he going to sit down in his sitting room and say, well, I like this or I don't like this? Discretionary powers must be exercised within some scope. So the question is, if I submit a complaint which falls within the scope, he needs to rank them and probably make a choice. Now the question is, if he's going to choose and leave some out, is that not exactly an issue about the scope?
You raised a point, and I think you touched on it about protocols. About
Yes.
just a second, about developing protocols.
Yes. And I mean, these are standard.
Yeah. So you
I'll come to
develop
justice.
protocols.
I'll come to you, Justice, because it's a point that I think you raised.
I think even with the DPP and there are, all prosecutions would have protocols as to the selection of cases, the management of cases, and so on. And yes, the focus was on politically exposed persons. And I think for me, I feel it's early to have this debate, because the problem that we are dealing with is not really a matter of scope. I think that if the OSP, all the things that we have suggested were done, at least we would have seen some of these cases moving faster. Maybe down the line, when there are so many cases, there are 300 petitions, and we can have a debate about scope. But what you expect the OSP to do, even at the initial stages, is once you are recruiting people, you should have protocols for investigations, how you conduct your investigations, how you select your cases, all of those things. Because that exercise of discretion itself has to be regulated in a way that ensures that there is not an abuse of the process, that you choose cases that might actually undermine the objects of the office.
If the primary concern now is not scope, then let's narrow down what the key issues are.
Yeah.
And you've outlined that. We've talked about, I think we can eliminate now finance, because I know we now know that amount of money has been budgeted for is there, he can access, except that for foreign grants, they still need, still needs to be sorted. I think the finance bit is sorted, correct?
Sure.
Okay. So we're left with building, I guess, physical space, which we've touched on already. But there's a very important one, and now we're going through the key things as you've identified, which is collaboration and cooperation. Which for me is so fundamental, and sometimes if not taking care can misinterpret as undermining the work of the OSP. And you cite some very fascinating cases I didn't know until I read it, which is the Metro Mass case. You said the person who, in the Metro Mass case, the complainant, I hope you were saying, who took the case to the OSP ended up being investigated and prosecuted by the CID. Meanwhile, the OSP was looking into it. In the case of the Galamsey case, the Anas famous case, the original petition that Anas filed was to the OSP. And yet we have an executive appointee, a minister, instructing the CID to also open a parallel investigation into the matter. And this is a trick. The police have a representation on the on the OSP, and you think that there's a very senior officer who sits there, and you think they can coordinate. That is a very serious problem.
Sure, and I mean, it's one of the things we draw on, because even as we are worried about buildings and so on, at least you have joint investigations going on. There's the task case with Yoko. There is what they call it, the ghost names case with the audit service. So the OSP has all of these pies that is cooking even at this stage. So there's a lot of working between law enforcement that's happening. And one of the things that we try to avoid in the legislation was that in delineating the scope for the OSP with corruption and corruption-related offenses, then all the agencies can also concentrate on
other things.
But there are overlaps. So if you take Yoko and the OSP, you can start on money laundering investigations and end up on corruption cases or organized crime. And the same kinds of things, it could be a drugs with NACOP and end up in corruption and so on and so forth. If you don't have protocols in place to address how you coordinate and you cooperate and collaborate, then you begin to have these problems. because all of these law enforcement run on a command control process. They report to somebody. So the IGP nominates the representative on the OSP board. And the idea that you had that was to help with the coordination.
Yeah.
But the person still responds to the IGP. And the Minister of Interior can give the IGP directions per the law. So if you don't have parameters for how you're going to handle the overlaps when they emerge, then people just act on their own. And that's where we are drawing that. This already gives us an example of where you, by duplicating functions, and then you're wasting resources.
Yeah.
Because you also then give the suspect room to maneuver. If I think I will do well here, I will move here rather than this place, and so on. So these are things that we think.
Or more seriously, when I read it, or more
with.
seriously, if you have an executive that is, I guess, minded to undermine the OSP, all they need to do is simply refer cases to because they appoint the IGP and they have influence on all the senior ranks. Refer cases to CID, make the OSP redundant.
Sure. And the point is that I also listed the powers that the OSP has. People have a duty to cooperate with the OSP and so on. But you are working within law enforcement. So you also don't want a situation where you are prosecuting the people that you're supposed to work with. Yeah. You become very unpopular. And in that kind of scheme, you are going to struggle to be effective. These, I think, are real pragmatic issues that even the board has to learn how they are going to manage those issues, because they are responsible for policy. Yeah. But as individuals, one-to-one, they are also operationally interacting. Yeah. So there's some fine lines that has to be.
Except that, though, Justice, I don't want to bring you in on this. You want to comment on this? Yes.
Yeah. You see, the more we try to abandon the scope issue, the more we go into the scope issue. Now, we are talking of overlap between institutional framework. That has everything to do with the scope, okay? Because if we delineate the scope clearly, we will be able to reduce these overlaps extensively. Now, what do we want to achieve? If it is the case that we just want to set up another institution to do the usual business as usual, then I can agree that we have achieved that. But if the purpose is to go back to the political real issue, the situation of fighting corruption within a government, then we have not achieved that purpose. And I am saying that we don't need another Attorney General Department, which has all the challenges that we've been talking about, which does all the things that we have been talking about. What we need is a special prosecutor to be more specialized in certain, areas of fighting corruption. What we have now, well, Kojo said it is not yet time to talk about the scope. Well, I think that we need to start talking about scope now. Otherwise, we'll put up all this and we realize that, look, we need to even put a bigger building. We need to even employ more lawyers. We need to even get more logistics. We even need bigger amount of money. Until we start talking about scope now, it is not too late it's not too early to start talking about scope. Until we deal with that issue now, all what we are seeing will just repeat itself throughout the course of the special prosecutors.
Let's talk about one of the practical things we just touched on, which is what we're beginning to see happen, which we've seen that they have raised, which is that, and we talked about it, there's some overlapping. And I make the point, I guess, more seriously, that for me, what is happening tells you that a government that is not interested in fighting corruption can simply come under the cover and render the OSP redundant and simply refer cases to their preferred forum, which is the police. And we've seen, and this for me is a question. For a government that fought for the OSP to be passed, in fact, it's the baby of this government, are you surprised to see that in the case, for example, of the Galamsey and NAS investigations, the Interior Minister is instructing the CID to investigate that matter, when already a petition has gone to the OSP. And you think for a government that, I guess, gave birth to the OSP, they would actually refer all other matters to the OSP and not to the CID. What's your comment on that?
Evan, I am not surprised in any way about that. Because, you see, the moment the government decided that it is not going to limit the special prosecutor to focus on persons in government, then we should have foreseen some of these things happening. What it means is that the good old political will question has not been answered, and the problem has not been resolved by the OSP. What it means is that the political person, the person in power, still has the power to maneuver and avoid prosecution. So therefore, what it means is that nothing new has happened. And of course, if I were a politician, why would I not refer the person to the IGP, where I know I will have a more control situation than give it to the special prosecutor? And if this is happening even in the government that is the mother of the OSP, you can imagine what will happen if the government, which is not the mother of OSP, comes to power. That is why I am saying that it is good to have institutions, it's good to talk about empowering them, personnel and all that, but the broader framework, the broader framework must be determined ahead of time. We don't need to say that we have to wait for 10 years to be able to determine the broader questions, because it is out of the broader framework that we can get the specific, what you call the practicals. If we don't get the framework well, we can do all we want to do about the practicals and the solution will not come out. So I think that it is time we started talking about these scope issue, and until we are upfront with it, we will just be doing the business as usual, talking about all the things that we have always been talking about.
Does the OSP have the power to take over corruption cases, for example?
No, but it was
suggested.
Yes, it was one of the.
But wasn't made part of the law.
It wasn't. So the only takeover clauses were in the transitional provisions that when the OSP came into being, if there were corruption cases, then the Attorney General could pass that over to the OSP. We wanted that takeover clause because it exists in other jurisdictions, so that it kind of affirms the jurisdiction.
So that if the police start some work on corruption, the OSP can go in and say, seize it,
because it's within my jurisdiction. But as I keep saying, yes, I mean, I think the scope issues were debated over again, during the deliberations. But the problems I see, as I said, is for me is early to be talking about the scope. There were going to be challenges like these overlapping mandates because people are used to doing these multiple. I mean, if you remember the Woyome case, you had the Yoko doing it, you had BNI, there were some national security. There's all kinds of people having the same multiple. So the law enforcement environment is kind of used to that kind of structure, and you have a new regime that you are trying to rein that in, and the OSP has to be, asserted itself in that response. And we as civil society and those who are observing the process have to push for those, boundaries to be set. So for me,
legally or administratively?
No, because legally, and I think Justice has, kindly talked about, all of the offenses that fall under that, including procurement offenses and then related offenses to any of those two categories. That is supposed to give you an idea of the boundary. But as I've explained, if you take Iyoko's mandate, Iyoko can start a case that is probably about organized crime and end up that becoming a corruption case. What happens, and this is practical, this is not, even if in this mind, it knows that it is only following organized crime. It becomes a practical, and this happens in every jurisdiction, even where you have, the boundaries sort of set, there are always overlaps, but there are mechanisms to deal with the overlap. So for me, even as we talk about all of these things, let's put in those mechanisms and try
that is what I want
out.
to go next, because my bigger concern, just a citizen, ordinary person, not a lawyer thinking about this, is, but remember, we'll have other governments. You don't know the caliber of people who form the government.
Sure.
is if the government fears the OSP because they didn't appoint, so Matami do we all know is fearless individual. All they need to do to kill a corruption case is to quickly get the CID to start investigating first.
Sure.
Because the CID is already well established, well resourced, etc. They have investigators, and they are going to give the OSP the investigators. Get in first and start investigating, and that quickly waters down what the OSP can do in the matter. And that will be a very effective way of the government controlling such corruption.
But that's why,
cases.
for me, the protocols.
That's a scary prospect.
That's why the protocols are important, and transparency around the protocols are important.
But the protocols don't have legal effect, do they?
No, but I think the OSP is operating based on law. So if there, as I said, there's a duty to cooperate with the OSP, right? It's in the law, it's in the act. So if protocols are agreed among law enforcement that this is what should happen, and we also know about it, because remember, it is not just the OSP that is going to make this office succeed. As we've seen it, all of the Scorpions or the EFCC in Nigeria and so on, it takes the public's monitoring and scrutiny to make sure that the right thing is being done because of the experiences that we know. And that's why we flag this matter early on, that we need to watch these things quickly before they become part of
what real solutions are there? Because I see that you asking the governing board to deal with the matter.
Because they were designed purposely for that.
What can they really do? What are you suggesting that they do to arrest this problem?
Well, because it's a coordinating board and most of the principals are already
out there.
That is why we are saying you have to come and develop a protocol that becomes part of the OSP's reference and guide on how it manages cases with everybody else. So that, as I'm saying, those things also should not be internal documents. These should be something that is transparent, that everybody knows that this is what happens when there's an overlap. The law will be respected, so that if somebody is using that route to maybe undercut the OSP, they can be called out. Because who's going to police the system if we don't get to know how these decisions are made? So for me, I think, yes, maybe I'm a bit too detailed because I'm watching every step of the process. But I think there are some things that have not been put in place even for us to now say, oh, even when you put these measures in place, it doesn't work.
I'll come back to you shortly and wrap up with what can we do going forward to make this really work. But Justice, finally to you, I guess right now, after 15 months, the challenges are very well known now, thanks to the work that Kojo and others have done. We know what the challenges are. What for you will be your own proposed solutions to making, we have the office now, there's nothing we can do about it. So how do we make it work efficiently?
You can recommend an amendment.
Effectively to serve the purposes as the law already details. What will be your recommendation?
Yeah, so I think the first issue that comes to mind is personnel, okay? And personnel, logistics, but all goes back to money. But what I would actually prefer that we take seriously from now is expertise. We need to train the prosecutor himself, the special prosecutor himself, and all the lawyers that we are going to recruit. These people need special training. When you go to the law school, you are taught how to just do the basics. But if you want to be a robust anti-corruption agency, then your personnel need to be different from the average lawyer that you find on the street. And so if we take that seriously, we'll make a good impact. And then the issue of collaboration. I think this is not the first time we are having a specialized anti-corruption agency. We have IOCO, which has been working alongside the police for some time. We have the Auditor General, who has also been doing this. We have SHRAJ. The issue of protocol, important though it is, there is a way these institutions have been handling it all along. So we need to develop that protocol, but let's focus on the issue of scope. For me, that is the ultimate, as Kojo rightly said. I would suggest that we start, thinking about the scope. Because just imagine that we limit the scope of the special prosecutor to the original intent. Go after persons who are in government, okay? And when there is a conflict between you and another institution in respect of a person who is in government, it is the special prosecutor who would, prevail. Can you imagine how much change this could bring in the field? In any case, the AG and all the other institutions are doing the other work anyways. The one that we have not been able to do over the years is the one that has to do with the person who is actually in government and has control over the IGP, has control over the Auditor General, has all this control. So if we want to solve that problem, I think that we should create that special vehicle. Until that is done, for me, we'll just be doing the usual discussions about personnel, finances, logistics, capacity, which would, in fact, all institutions need these things anyways.
I'm grateful.
Yes.
I'm grateful that you have those thoughts. And Kojo, so as I said, the vehicle is already here. There's nothing else we can do than to work to make it work the way we expected it to. So we know what the issues are.
That's right.
Do you see commitment? Because I guess the purpose of today's work that you put out was not because you love talking.
No.
It's because you, first of all, want to bring sunshine to the problem. And most importantly, want the people who really make the decisions to take note and fix the problem. Right. Do you see commitment to address the challenges?
Yeah, I mean, I think the money that was voted was an example of commitment. I think for me, though, is that we see a lot of bureaucracy around some of these processes of handing over. Mr. Amido is quite very strict on procedure. And I think sometimes people are still hoping that he will be a little more relaxed. I don't think that would happen. So I think that the executive has to understand that they are dealing with a person that wants, so just apply the procedure, but speed it up, rather than trying to have an alternative way of doing it. And I think some of those kind of problems has allowed the delay to happen, because he is not going to change his position.
One of the key things is recruitment. And a note that you say that the president should delegate.
Yes, yes.
Has the president appointed all those he's mandated to appoint, to recruit?
No. So I think, as far as I understand, in terms of other staff, so the board is supposed to advise on senior members, but other staff appointed by the president. I think, I mean, can you imagine 249 or so people envisaged to be employed? All of that has to go for the president for appointment. And I mean, so I think they have to delegate that power either to the board or the special prosecutor himself. And Article 195
but the president hasn't done so.
Yeah, that's see, when you go to the law, you come across quite a lot of very interesting things, because unless you have sat down and read the law, in the finance minister's case, I don't think the finance minister thought he had any responsibility specifically in the law, apart from the budget, until that is pointed out.
But the government crafted the law.
You are talking about the government. The
president must have read every single line of that before it was passed.
Maybe the president.
And cabinet as well.
But I don't think. How many laws?
Drafts don't go to parliament until cabinet approves.
I don't think you have been around long too much.
No, because cabinet must approve
even
it.
in parliament, there are very few people who actually get to do. So I mean,
so are you saying that the president doesn't know he has to do this appointment? That's why he's delayed.
No, I think once you pass the law, I mean, in terms of implementation, apart from the main person who is the fulcrum of that implementation, who would point out that Session 2 or Session 3, most people just forget about it.
Okay. Hopeful though that next year by this time we'll have a different story.
I'm hopeful.
Kojo Asante, thank you very much. Dr. Kojo Asante with the CDD. Justice Termsai, I'm grateful that you joined us on this matter. Hopefully, as he says, next year we'll return to this conversation.
We'll return to the
scope. We'll probably have at least one case effectively prosecuted and whatever, the judgment or the verdict known, and then we can hold on to that and run. Remember, the next year is an election year. Matamidu himself has said that if this delays and they start prosecuting into 2020, then the politics now become even more difficult to extricate. But that's it for tonight. Enjoy the rest of your evening. My name is Evans Mensah.